There you go.
There you go.
Okay, so we're live. My name is.
I got it. Okay, good.
All right, excellent. My name is Alex Simon. I'm the Director of Development and Communication for the Legal Aid Society of Mid-New York. We serve 13 counties in central New York and provide the community to free civil legal counsel and advice in Syracuse, Utica, Binghamton, and Watertown, as well as several other areas in the state of New York. I'm joined by Carlos Negron, who is a second year at Syracuse University, and the Honorable Judge Jonathan Lippman. I'm going to do a proper introduction for Judge Lippman. The Honorable Jonathan Lippman, former Chief Justice of New York and Chief Judge of the New York Court of Appeals, the state's highest court, is of counsel in the New York office of Latham and Watkins LLP and a member of the firm's litigation and trial department. He provides strategic counsel to clients on New York law and appellate matters nationwide and is the leader of the firm's pro bono practice. Judge Lippman served as Chief Judge of New York State of the state of New York and Chief Judge of the Court of Appeals from February 2009 to December 2015. During his tenure on the New York Court of Appeals, Chief Judge Lippman authored major decisions addressing constitutional, statutory, and common law issues shaping the law of New York, the contours of state government, and the lives of all New Yorkers. As the state's chief judge, he championed equal access to justice issues in New York and around the country and took the leadership role in identifying permanent funding streams for civil legal services. Thank you, Judge. We are indebted to you for that. Chief Judge Lippman made New York the first state in the country to require 50 hours of law-related pro bono work prior to the bar admission and established the Pro Bono Scholars and Poverty Justice Solutions Program to help alleviate crisis in civil legal services. He strengthened the state's indigent criminal defense system, addressed the systemic causes of wrongful convictions, created human trafficking courts across New York State, and led efforts to reform New York's juvenile justice system, bail and pretrial justice systems. Judge Lippman championed the state's commercial division of world-class venue for business litigation, reformed the state's attorney disciplinary systems, and adopted a uniform bar exam, and succeeded in the creation of a statewide salary commission for judges. Chief Judge Lippman has served at all levels of New York State court system in a career spanning more than 4 decades, including service as staff attorney, administrator judge. From January 1996 to May 2007, he served as the longest tenured chief administrative judge in the state's history, playing a central role in many far-reaching reforms of New York's judiciary and its legal profession. From May 2007 to 2009, Judge Lippman served as the presiding justice of the Appellate Division of Supreme Court's First Department, dramatically reducing the court's pending backlogs. In 2008, Judge Lippman received the William H. Rehnquist Award for Judicial Excellence, presented each year by the nation's Chief Justice to a state court judge who exemplified the highest level of judicial excellence, integrity, fairness, and professional ethics. Judge Lippman was selected for his unparalleled ability to promote and achieve reform in state courts. His leadership in New York courts contributed to numerous improvements in that state's justice system and served as an example for courts across the country. In 2013, the American Lawyer named Chief Judge Lippman one of the top 50 innovators in big law in the last 50 years. A New York Times article in December 2015 stated that Judge Lippman had left an an altered legal profession in New York by using his authority to promote an ideal of lawyering as a public service. We're going to talk about that. Judge Lippman was the 2016 American Bar Association's Jonathan Marshall Award recipient, an honor whose prior recipients include Supreme Court Justices Anthony Kennedy and Sandra Day O'Connor. Judge Lippman presently serves as the chair of the Independent Commission on New York City Criminal Justice and Incarceration Reform, a 27-person blue ribbon commission formed to examine the future of Rikers Island jail facilities in the context of systemic criminal justice reform. Judge, did I miss anything?
No, you absolutely got every single thing. All good.
Good. Judge, as I mentioned before we started recording, we just want to have an open discussion with you. You've dedicated your life in many ways to pro bono advocacy and advocacy of the civil legal services across in the state and across the country. So we're just excited to have a great conversation with you. I just wanted to start off with, what are the essential benefits of civil legal aid in your estimation?
Well, the bottom line is that justice really can't be about the amount of money in your pocket or the color of your skin. It's got to be equal for everybody. And a way to ensure that is to ensure that everyone has representation in court and quality representation, so that the scales of Lady Justice are, exquisitely balanced. And that, we make sure that justice is not some abstract term that doesn't have any concreteness to it, but rather it should be real and tangible for everybody who comes into our court seeking justice. So that's what it's about. And civil legal aid, ensures that that's the case. The civil legal services organizations, to me, are the real workers in the vineyard for equal justice in our country. And without them, we certainly would have a great difficulty in making sure that the system is fair and impartial for everybody. There can't be an imbalance of power when you get into the courts. Everyone deserves representation, and that's the whole idea of civil legal aid or civil legal services. And no less so, let me say too, that concept, of course, applies equally to criminal justice, and that the right of everyone to have a qualified attorney. The difference is, and I'm sure we'll get into it, is that on the criminal side, the Supreme Court of the United States has said that there's a constitutional right to legal representation if your liberty is at stake. On the civil side, the U.S. Supreme Court has not, certainly as of yet, made that the case. So we rely on, because of that, civil legal services and the pro bono work of the bar. That being said, even with the criminal right to legal representation, the promise of Gideon, that's from Gideon versus Wainwright, which was the seminal U.S. Supreme Court case on legal representation. But even with that, the funding is very unequal around the country. So it's almost bittersweet that at least there's that constitutional right, but fair to say that it's bittersweet that even with that constitutional victory in the Supreme Court some 50 years ago, again, in different parts of the country, criminal representation is not what it should be. But again, the difference being on the criminal side, you have the constitutional right. On the civil side, no such thing, and therefore we're so heavily reliant on civil legal services and the pro bono work of the bar.
Excellent. We're going
Excellent.
to do a back and forth. So Carlos, you take the next question.
Yes, and Judge, I would have to say that I would agree with you. My experience at the Legal Aid Society of Mid-New York has certainly reinforced those points you have just made about equal access to justice. I would like to ask, Judge, because you have the distinct pleasure of enjoying a career that spans 4 decades. And during that time, you both championed and witnessed our state's emergence as the leader in civil legal assistance. What do you believe, Judge, is the reason other states have not adopted the same reforms that New York has?
Well, in my view, Carlos, is that as lawyers and as judges, we have a tendency to look at the four corners of our legal papers rather than at the bigger picture of justice and making sure, again, that the playing field is level. So I think that we're a tradition-bound institution, and we sometimes are too micro-focused on the particular legal case and what the arguments are, again, rather than looking at the big picture. So I think it requires a leadership in the different states, and I think it also requires an understanding by lawyers, by judges, by everybody, that we have a responsibility beyond just earning a living for ourselves. We have a responsibility, almost an obligation to ensure that there's equal justice. And so that's the problem, and I know when I was a member of the Conference of Chief Justices, when I was a chief judge in New York, a little bit when we first starting this kind of thing about asking chief justices and different court systems in the different states to be more vigilant in terms of fostering access to justice, a little bit, they looked at me like I was crazy. What's he talking about? We have these cases and we come in and we decide them. And that's what we do. But you know what? We do more, and it requires again, a affirmative commitment to making sure that everyone gets a fair shake. And so I think that's why, to some extent, it's the nature of lawyers and judges. We just have a tendency to kind of concentrate too much on the micro without getting the bigger picture. And I think those states are changing, and there's a lot of interesting things happening around the country. And there is, leadership in different states. So I think we're getting there, but not nearly as quickly as we should.
Thank you, Judge.
So speaking of leveling the playing field, you're an advocate of pro bono work, as you foreshadowed and mentioned there. So much so, the New York State Bar Association named an annual pro bono service award with your name. Why is it important lawyers serve the needs of the community? And I think you alluded a little bit to it, but this idea of practicing and being a kind of responsible to your business and to your income and to your own livelihood, but also giving back, serving. Why is that an important component? And why do you advocate for it?
Well, I think the idea is that when we admit you as a lawyer, we do so with the expectation that you'll aspire to the highest values of our profession. And lawyers have to understand that that's a privilege, but along with it comes responsibilities. And, again, if you look at your job in a vacuum, that I'm being a lawyer so I can have 2 cars in the garage and a nice income for myself and my family, maybe you miss the boat as to what lawyers are not. Maybe I think you do miss the boat as to what lawyers are all about. Lawyers are there to help people, to serve people, and that's why you you are given that privilege of being a lawyer, and that's why it's so essential that you help people in your community. You have this honor of being able to practice law in the state, and that comes with obligations and responsibilities. And this goes back to, as long as there have been the lawyers and the judges, our job is to pursue justice, and it's not just to say, gee, I want to earn some money and have a good income. And, the Old Testament goes back to talking about in the Deuteronomy, which talks about, Moses being a one-person judiciary originally, and then realizing that they had to get others to be judges because one person couldn't do it. And they had all the problems, after he came down from the mountain with the commandments and all of that. When the Bible talks about, Testament, justice shall you pursue for rich and poor, high and low alike. So this goes back not only to, since we've been admitting people to practice law in New York and elsewhere, this is so much a part of our the values, the principles, the ethos of the law, and being a lawyer, and having a justice system that's fair and even-handed. So that's really what it's all about, and that's why it's so important that lawyers follow through on that. Again, this highest principles that our profession is all about, and have been forever.
That's such a good point, Judge. And in a minute, I would like to come back to it because it reminds me of one of my favorite Judge Lippman quotes. But I remember, Judge, the 2010 report on the task force to expand access to civil legal access in New York. And that task force estimated that our state's unmet civil legal assistance need costs New York taxpayers millions of dollars by increasing homelessness and poverty. Could you tell our listeners and our audience about how this justice gap costs our state millions?
Yeah, the idea is that people all across our state and the country are fighting for the necessities of life. They fight for their roof over their head, their physical safety, their livelihood, the well-being of their families. And when it comes to such things that really are traumatic for the average person, they need legal assistance. And if they don't get it, those people can literally fall off the proverbial cliff. And if they do, they wind up in poverty, disruption to their families, maybe to drift off into crime. All these things result in poverty, homelessness, criminal justice complications. So it's not just, we all lose if people fall off that cliff. So that's what we mean when we're talking about costing the state, the justice gap, costing the state millions and millions and millions of dollars.
Thank you, Judge. And going back to your earlier point, as Alex said, I'm a Syracuse law student. So Syracuse through and through, I have been following your career. And I always remember one of my favorite Judge Lippman's quotes was, when human beings are in distress and there is suffering, it is then that the legal profession is called upon to be at its noble best. Now, as a law student, that's a quote that sticks with you. That's an ideal that I strive towards. But I must ask, because at the time that you said that, New York was leaving a very difficult moment, and I feel like today we are as well. Today, as we are leaving one of the most distressful times in recent history, do you believe the legal profession is at its noble best?
To be honest, no. I always refer to the nobility of the legal profession, and in so many ways it is. And look at over all the years, after 9/11, after the storms that were so Hurricane Sandy and all that stuff. Yeah, the bar has always risen to the occasion. I mean, right now I'm heading a group that is put in place by the state bar and the state court system to get lawyers to help people severely impacted by COVID-19. And in all the different ways, from the roof over your head to health problems, insurance problems, everything else. And yes, there are so many lawyers that do have a sense of that nobility and do rise to the occasion. But I have to be honest, Carlos, that if you look at how many people really participate in pro bono and helping those in need, particularly at times of crisis, you know, if you have 30% of the bar doing that, it's a lot. 30% of the bar does almost all the pro bono in the state, and everybody else, you know, not so much. So, so I think that that can be disappointing and does lack that nobility and that we always talk about that the bar has. And that's why, Carlos, and you'll be facing that soon, and I'm sure at Syracuse, you'll be doing it anyway or have done it. That's why we put the requirement of 50 hours of pro bono for everybody before they can be admitted to the bar, to get into the DNA of particularly young people, newer lawyers, the DNA about what lawyers are supposed to do. And that for I'm hoping that by doing that, we get written on the forehead of those new lawyers that this is what I am as a lawyer, so that in the future, we don't have this issue. Are we meeting our obligations? But everybody, as a matter of course, you know, does what lawyers are supposed to do, and particularly important in times of crisis. And yes, in so many ways, we do rise to the occasion. But I have to be honest, in so many ways, it's disappointing that not enough of our colleagues do. And we have to continue to stress how important it is. And particularly when you talk about civil legal services, we need that combination of not only the workers in the trenches, the legal aid lawyers, but also the voluntary pro bono efforts of the bar is so important that every day we rise to the occasion, but even more so the pandemics, the terrorism, whatever it might be.
What a great answer, Judge. Thank you. And I must say, at least personally, I think those reforms that you have pushed forward have certainly achieved that in me, in cementing that pro bono DNA.
Oh, thank you, Carlos. But you know what very much troubles me? That if you look around the country, with the only state in the nation that requires that. And I know California had it under consideration for a while, and some other states have, but it's almost a resistance by part of the bar that almost a self-serving approach that says, gee, if we make the younger people do it, the kids in law school, then they're going to make me do mandatory pro bono. And wouldn't that be a terrible thing? And we've got to get out of that kind of parochial attitude. And my answer is, no, it wouldn't be a terrible thing at all if every lawyer in the country, in New York and around the country, did 50 hours or 100 hours of pro bono work, were required to do it to help the poor and the vulnerable. I don't think it would be terrible. I think it would be great. Yeah. But there's a natural it's not limited to the legal profession. We are all, parochial to some degree. And we've got to get out of that, particularly lawyers, who are so important to the well-being of our communities and our nation.
Well, Judge, you just mentioned that several colleagues did not put as much time into serving low-income communities and advocating for pro bono and championing for civil legal service and investing in civil legal services. Outside of the logical reasons, as you said, the efficiency, saving costs to the taxpayers. I'm trying to scale back the layers of the onion for you. Why have you dedicated your life and your career to this? You mentioned a little bit of the Bible, the Old Testament, and some of the values that you probably have dating back to your youth. But why are you so passionate about this personally?
Well, I had a little different career path than most people who, become the heads of the judiciary, the chief justices, the chief judges. I grew up in the court system, and in the trial courts, and I worked first as a court attorney. We used to call them legal law assistants. Now they call them court attorneys that write decisions and draft decisions, write memos for the judges. And then I kind of segued into court administration as the chief executive officer and chief clerk of a particular trial court. In my case, the Supreme Court in New York County. And as you know, in New York, the Supreme Court is not supreme. The Court of Appeals is. The Supreme Court is a general jurisdiction trial court. But in all those roles and growing up in the court system, I saw the thousands of people streaming into the courts every day seeking justice. And maybe I got I used this term before too, more of a macro view of what it's all about, and a recognition that that again, justice has to be real and not just some vague term that we talk about. And so my career path, before I even went to the judiciary, I had a full career, as a non-judicial person, as a lawyer in the system, as a high-ranking clerk in the system, as an administrator in the system. And by the way, when I first became the deputy chief administrator of the state court system, still a non-judge, that's how I got to know, Syracuse and all the different parts of the state. I mean, I was a kid from Manhattan. I didn't, really hadn't known much about New York State, but eventually got to all of the counties and every part of it, from the southern tier to the western part of the state, all the way out to the island, everywhere. And I think that by the time I became the chief judge, I had a very different view than the average judge, if there's such a thing, who works themselves up. They become maybe a lawyer, they become a trial judge, they become an appellate judge, then they become the chief judge. And for me, I was not a judge most of my career. And it was only by having that early grounding in justice, in human beings who are seeking that justice, that maybe, and also I had experience in how to change the court system, being in administration part of the time, that when I became the chief judge, I kind of hit the ground running on issues relating to access to justice and equal justice, that maybe the average person who becomes a chief justice or a chief judge really doesn't have that background. So I think times are changing, and that people get it, that people in the judiciary get it, lawyers are starting to get it, that we can't sit by idly when people are denied access to the courts,
Excellent, Judge. You mentioned, Judge, and New York has a distinct privilege that here civil legal services, they have a unique funding structure. But even civil legal aid fails to serve all clients and needs.
Yes.
they often must even turn away clients. You mentioned earlier about how the private bar and pro bono can be a solution to this problem. Do you think that we should invest more in legal services at the federal and state level, or do you only see the private bar as the solution to this gap?
Well, I see both, Carlos. I don't think you can do it without both. I think, in my tenure, I changed the idea on the funding side that whatever funding we have to have must come from the federal government. The Legal Services Corporation, which is wonderful. It's the largest provider of civil legal services funder in the country. But we started in New York State to make the state and the city a funder, and now the state provides $100 million a year to legal service providers. The city is providing even more funding, including relating to the new civil Gideon legislation there. And so I think that civil legal providers turn away more people than that. It's a fact, not that I think, turn away more people than they can help. So obviously there isn't enough funding in the world, even when increasing the federal and the state, which we must do. You're still going to require that voluntary pro bono work by the bar. And as I indicated before, in my view, or I really didn't have this view for a long time, I thought that it wasn't necessary. I would advocate at this point, given that after all these years, we still have, what did I say to you, maybe a third at most of the lawyers do almost all of the pro bono work. I would not be against the same requirement that we now have for the to be admitted to the bar for all lawyers. And so pro bono by its nature is voluntary, but if we can help it along a little bit by requiring maybe a pittance, 50 or 100 hours, I think that's a good idea. And that lawyers, some of the organized bar is afraid that what we've done with the 50-hour requirement for law students is the nose under the tent for mandatory pro bono for all lawyers. And well, that really wasn't the intent. It was more a licensing requirement for new lawyers. In my view, as Seinfeld would say, not that there's anything wrong with it, I think it's a great idea for lawyers to do that or be required to do that. But obviously, that's why we've done with the new lawyers the 50-hour requirement. So it's in your Carlos, in your DNA. Mm-hmm. You don't need it to be mandatory because you get it that that's what lawyers do, and that's who you are. And I think that's kind of what we're trying to do. So however it gets done, it needs to get done. And so you have to have continued funding and definitely continued pro bono work without question.
Excellent. I would add that partnering with great organizations like Legal Aid of New York, Legal Aid of Mid-New York, and the LSC are also great ways to cement that. So I invite all law students, incoming attorneys, and current attorneys to try to get in with these organizations that do so much and even help with your current costs with COVID-19 legal aid and legal relief.
And our theory, Carlos, was that a lot of those people who are doing those 50 hours of pro bono and people who are part of the pro bono scholars program that, requires the last term of law school to be devoted to pro bono, that or to helping poor people, that a lot of those people will choose to be legal services attorneys, and we had another program, Poverty Justice Solutions, that got lawyers 2 years internships at legal aid organizations. So yes, we would very much like that newer lawyers see that as being a rewarding a place to be. And I don't only mean in terms of compensation, but in terms of career satisfaction and helping people.
And I think you're close to succeeding in that, Judge, because from personal experience, a lot of my colleagues, they participate in the Pro Bono Scholars Program, or they participate in these equal access initiatives, and I do see them go on to participate in these organizations later as well.
It warms my heart. I hope so.
Judge, you have often said that we have a constitutional duty to provide equal access to justice, turning the conversation a little bit to equal justice, equal access. Now, at the same time, like you mentioned, the US Constitution grants no categorical right to counsel in civil cases, but there is a movement, and we've hinted to it, to establish this right, especially in New York City, for low-income tenants facing eviction. And throughout your career, Judge, you've seen a lot of change. Do you see a future where there is a right to civil legal counsel for at least the essentials of life? Do you see it as a reality?
I do see it, although I don't see it right away. You know, if you look at the U.S. Supreme Court rulings, Turner versus Rogers, and some of these cases, they've actually rejected that approach. And what's going to change this over time is either constitutional change, like you'll get a case that goes up where they change it, statutory change, which is like what happened in New York City with civil Gideon legislation, basically saying that everyone who's the roof over their head is threatened has to have an attorney, or very important, by policy. What's happening is a lot of things that we're doing in New York and are happening around the country change the public's view of the need for legal representation. If you look at the criminal side, 20 years before Gideon versus Wainwright, there was a case called Betts versus Brady, where the Supreme Court rejected the idea that if your liberty is at stake, you get a lawyer. What happened in the 20 years between Betts versus Brady and Gideon? What happened is a lot of interesting things were happening around the country. People were experimenting with providing representation in criminal cases. So by the time of Gideon, public opinion had changed, and 20 or 25 attorney generals from different states put in amicus briefs to the US Supreme Court saying, yes, there's a constitutional right. So what we're hoping will happen in the civil is the same thing, that as we do interesting things, whether it's the new legislation in New York, whether it's policy initiatives like we've done and what other places have done around the country, that the public's viewpoint will change. Because if you look at the law, follows public opinion to a great deal, despite all the stuff about originalist views on, constitutional issues. Look at it. The law follows the change in mores and the change in values, whether it be same-sex marriage or so many other things, segregation. As views change, the law changes. So we're hoping that the same thing will happen. Because if you go to the average person in the street today and you say, if someone's going to go to jail, should you have a lawyer? 100% people would say absolutely. Why? Because the thinking of the public has come around to that view, and Gideon reflected that idea. So it is my hope that over time that same view will be, and if someone comes to you in the street and says, hey, if they're going to take away the roof over your head and your home, should you have a lawyer? I would hope that down the road that 100% of the people would say, you bet you should have a lawyer. So that's the kind of opinion changing in the consensus in the country that results from doing interesting things, and maybe when people look at the reduction in the number of evictions as a result of that new legislation, they'll see that how valuable this is, legal representation, how essential it is, So
yeah, certainly the justice gap affects all of us in different ways. Judge, you have inspired a generation of lawyers and students like me to take on the fight against unequal access to justice. Yet legal education, like all education, has become more expensive, and it has forced students to go to private practice rather than public interest work. What role do you think law schools have in filling in this justice gap?
I think they have a critical role. And my view is that if you require law students to learn about torts and contracts and whatever it might be, you also have to require them to learn about values. And that's the role of the law school, to teach lawyers what it means to be a lawyer. And that value system should be integrated virtually into every one of those disciplines that law schools teach. They also have to teach about who we are as lawyers, what it means, and I think that's critical. So I think lawyers are at the forefront of how you do that, how you close the justice gap. Every single person comes in and out of law school should feel that they have a role to play, a critical role in closing that justice gap. So law schools are great. And again, like everybody else, I think law schools are getting it, and we hold conferences in New York of all the 15 law schools every year on access to justice. And so I'm high on our law schools and high on the fact that they are leading the way in terms of having students not just have a technical knowledge of the law, but understand what it means to be a lawyer.
Thank you, Judge.
Final question, Judge Lippman. What advice would you give attorneys and students thinking about getting active in pro bono work? And I'll also say, what advice would you just give law students and young attorneys who I think, and I don't know if I'm right in this, Carlos, but they feel that they might get branded one way or the other early in their career by taking a certain path. What advice would you give them long term in their career? And yes, as I said, touch on the pro bono as well.
Well, not to start off on such a serious subject with a bad joke, but you remember what Yogi Berra said, that when you come to a fork in the road, take it. Yeah. So career path comes to all of us. We come to forks in the road, and what do you do? And my advice is, number one, you follow your passion. And if your passion is commercial law or whatever it is, you should do it. There's nothing wrong with that, as long as you don't forget that in addition to exercising that passion, you also have to help pay people and do pro bono work and do all the things we've been talking about today. And that, to me, the path to satisfaction or fulfillment in your job is that you feel it, you understand what it means to be a lawyer, and that's how you have a career that's meaningful beyond the 2 or 3 cars in the garage, and I think there's an innate, and Carlos, you've seen that, and that's why we're doing the 50 hours requirement, that when people do it, they get that sense, they wind up doing much more than 50 hours.
Yes.
They get that satisfaction, the feeling of well-being, of helping other people. And so I don't see, look, one person may feel the need, the call to become a legal services attorney, and another person wants to be a negligence attorney, or they want to go into public interest law, or they want to go into commercial law. There's no right and wrong. But I think part of being a lawyer is to recognize our responsibilities to aspire to the highest values of our profession. And that means clearly, no ifs and buts about it, helping people, serving others. That's what we do. In my view, that'll make you happy about a career in the law. And it's done it for me, and it's done it for so many others. And I think to miss that, you're missing so much of what our great profession is all about. And I come back to the word we used before. You miss the nobility of that profession, going back, again, the times immemorial. Let's go back to what we talked about from the ancient times. We all should be pursuing justice. Justice shall you pursue. That's what we have to do. And there's nothing wrong. There's everything right about holding that as your guiding principle, being proactive in the pursuit of justice. That's what it's all about in being a lawyer, at least certainly in my mind.
Yeah, there's something about attorneys and young and law students that are attractive to folks that are not inside the legal profession, because you have been trained in arguments and standing up for yourself. And I think the average citizen is not necessarily aware of alternative possibilities in their life. And I think when they get access to an attorney, things open up for them, and they can become, I was talking to another colleague of mine, many people that we work with become whole. It's actually, as I think Judge Lippman was mentioning, it's important to the economy. I mean, the people that we uplift just in dealing with consumer cases are dramatically impacted for the rest of their life. So it's an economic driver in our society. So yeah, it was a super insightful conversation, Judge Lippman. Carlos, do you have any closing thoughts or ideas, questions?
No, I just wanted to again thank Judge Lippman. It's such a privilege, such an honor, speaking as a law student, speaking as a future attorney, to have this conversation with you, to somebody who has done so much for this cause and continues to do so. You're quite an inspiration. Thank you.
Well, thank you both. Thank you, Alex. Thank you, Carlos. It's been a delight and a pleasure. Keep up the good work.
Will do.
Thank you, Judge Lippman. This recording will be available on YouTube and all of Legal Aid Society of Mid New York's social channels. And yeah, thank you, Judge Lippman. We look forward to it, and we will follow up with the recording and other things as well. So thank you so much for your time.
My pleasure. See you both. Bye-bye.
Bye.